Good morning. My name is Laura Liu with Community Legal Aid of Southern California. And on behalf of the County of Orange, California, and our World Elder Abuse Awareness Day Committee, I want to welcome all of you to the 2025 World Elder Abuse Awareness Day event. Our webinar today includes two guest speakers, Edie Mermelstein and Kelly Morris, who will provide proactive strategies to prevent elder abuse through legal and financial planning. Now we will get started with some housekeeping. This webinar is being recorded and will be available to all attendees in case you would like to go back and reference any of our slides, resources, and other materials. You have all been muted by our webinar administrator so we can avoid any unnecessary background noise. Your audio, how loud we sound to you, is controlled by you, though. You can adjust your volume on whatever device you are watching us on. The hand-raising feature has been disabled too. This leads me to our next agenda item, which is how to ask questions. What you are seeing now is a screenshot of the Q&A box, otherwise known as the question and answer box. During the presentation, you will be able to type in questions for our presenters. We have committee members reviewing these throughout the presentation, and we'll ask the questions of our speakers at the end of their presentation. Your question also might be responded to with some helpful information and links. Please remember not to wait until the end of the presentation to ask your question, as we will all be gathering these questions for the speakers throughout their presentations. Continued education credits for today's events are provided compliments of Alzheimer's Orange County. Here are the basics of those of you who wish to be certified for continued education credits for attending today's events. You must attend the entire event from start to finish. You must have access to both sound and visual elements of the presentation. You must respond to the poll questions during the presentation. If you are unable to enter your answers to the poll questions for any reason, please type your answers in the chat box instead so that you qualify for CE certification. And finally, you must complete the course evaluation. When you leave the webinar, a window will automatically pop up to start the evaluation. So thank you again for joining us today. Now I will bring in today's moderator, Libby Anderson.
Thank you, Laura, for that wonderful welcome. My name is Libby Anderson with the Council on Aging, and I have the pleasure of serving as the moderator for today's event. We'd like to thank Radiant Futures at the outset of today's event for sponsoring our opportunity drawing. If you participate in the evaluation following our webinar, you will be entered into an opportunity drawing to win a $100 gift card from Amazon. There will be a total of 10 winners. You must provide your age range when completing the evaluation in order to qualify for the opportunity drawing. I'd also like to honor the Planning Committee, which has been working for the past 9 months on today's event. Thank you all for your commitment, time, and energy. We are very excited to bring you the information today from our speakers. And before we introduce our speakers, I would like to bring your attention to an important disclaimer. Although both of today's presenters are practicing attorneys in the state of California, no attorney-client relationship or privilege is established between our presenters and attendees of today's event, either by virtue of the content of their presentations or any questions they may answer during today's event. And furthermore, no attendee should act or rely solely on the legal information in the presentations from today's event. It's recommended that all attendees consult an attorney licensed to practice in their state to obtain appropriate legal advice. And now I'll hand things off to Johanna Ramos from Providence St. Jude to introduce our speakers.
Can you see me? Thank you, Libby. Our first speaker today is Edie Mermelstein. She is the founder of FEM Law Group, a California-based firm specializing in trust and estate litigation, financial elder abuse, civil appeals, and consumer rights. Edie holds a BS from the University of Southern California's Marshall School of Business and earned her GD from Abraham Lincoln University. Admitted to the California Bar in 2007, Edie has argued before the U.S. Supreme Court and was a finalist for the Consumer Attorney of California Street Fighter of the Year award. She has been named a super lawyer every year since 2018. A passionate advocate for women and vulnerable communities. She serves as co-president of the California Women's Law Center and sits on the board of Breast Cancer Angel and the Auschwitz Study Foundation. Her work blends strategic litigation with unwavering commitment to justice and community empower. Without further ado, please welcome Edie Mermelstein.
Good morning, everybody, and thank you for being here. I know it's a lot taking time out of your day, and I'm hoping that you will be able to get some real nuggets to protect the vulnerable seniors. Everybody here on this webinar, I would assume, either is helping seniors, is a senior, or has a senior in their life. Regardless, we all have seniors in our communities, and part of the presentation today is I really want to focus on how we can prevent isolation and avoid conservatorships. Conservatorships may be necessary. However, there's some tricks and tips that I'm going to give to you for your seniors, or if you're a senior that has capacity that doesn't want to be deemed incapacitated by the court and come over the court supervision, then I'm going to give you some tools to help with that. And so is Kelly Morris, the speaker that's going to come after me. And if we could go to the next slide. So the learning objectives today, by the end of this presentation, I would like you guys to be able to understand, first, isolation is really evident in my practice. I usually get called in. So I'm an attorney. I work in Southern California, and I'm seeing more and more and more of these cases where isolation is really the precipice to financial elder abuse or physical elder abuse. So I want to talk to you, and I want you guys to understand how isolation works and what it looks like, so you can identify it and what tools you can do to report it, to prevent it. I would like to identify all the warning signs and risk factors. So as we're going through the presentation, I'll be sharing with you some of the things that I see on the ground and how it's affecting the seniors and the families of the seniors. And then if we can apply tools, we can actually disrupt or prevent isolation. I actually had one case come up. I had some attorneys that were really, really concerned just recently of an elder whose telephone number had been changed by a bad actor. Fencing was put around the house. They weren't answering the doors anymore. And their biggest concern was how to disrupt or prevent the isolation from getting worse without triggering and tipping off the bad actor so something worse could happen. So we'll look at that. And then I'm going to talk to you about supported decision-making agreements and how those function and how those can actually be a tool that has been put into the California state law in 2023 to allow it to actually be a basis so that you're supported, you could get the senior to agree to supported decision makers ahead of any incapacity. And I'm going to talk to you about that. So I want you also to learn about the alternative to conservatorship. So financial exploitation. There's an isolation pipeline. It's very clear to me on the ground that many abusers use isolation and take the senior away from their family members, their community, and then put into play different procedures to be able to. I mainly focus on the financial abuse. So it's taking over their bank accounts, getting title to their homes, becoming the sole beneficiary on an estate plan, all at the at at the expense of the family on the other side. And definitely during the life of the senior, it really puts them in harm's way. So it usually begins with trust. It could be a in the form of a caregiver. It could be in the form of a friend, a family member, somebody that comes in and intimates into the senior's life. Once that happens, they start getting the senior to trust. Now, when we're talking about seniors as a vulnerable population, we're talking about the aging process that all of you are most likely familiar with, the starting, the slipping of memory, the short-term memory might go. And people are very proud. So unlike the one side that we all know is being a baby and taking care of a baby comes into this world without a lot of, well, with no experience of the world, and we teach it and we protect it and we care for it, for the baby, and the baby grows, and we're very protective. As an adult gains their independence, and I see this especially with people that had very successful careers, and they might have by choice not had children. They might by choice not have relatives that are close. They may have family members and children that have moved out of state. So a lot of that is something where it breeds isolation just right there. So you have to kind of figure out who these people are that are supposed to be in the person's life. But then all of a sudden, when you get somebody in the mix that's really isolating, they're getting the senior to trust them. And as they isolate, and I've seen this a lot where they change the telephone number. So all of a sudden, the son who might call every week on Sunday, he might start figuring those things out. One of the things that I do tell people to do if they do have out of state relatives is put yourself on a schedule so that you can identify whether there is an isolation pipeline starting, because all of a sudden you can't get in touch with mom on Sunday at your regular time where you call in. As isolation happens to a senior, the control over that senior deepens. And so we have to figure out a way to disrupt this whole process, because what I'm seeing now is there are so many seniors, and if we just look at Southern California, there are so many seniors that don't have a family member that can actually advocate for them. So they are relying on friends, they are relying on caretakers, they are relying on different people that come in. It might be the dog walker, it might be a child that never launched and is living at home, and then that child becomes the isolator. So isolation is the pipeline. And once they get trust in the senior and they have the influence, the isolation happens. That's when the control will happen, because there's a shift, and then there's exploitation. So I'm just going to talk about a case that is hypothetical, but it fits into a lot of the dynamics of the cases that come through my office. Now, as a litigator, I usually see the cases when they've gone too far, when the prevention wasn't done and the family members are just discovering this. So let's take Martha. She's 82. She meets a very helpful handyman. He's great. He's terrific. He's fixing things for her. She used to be really handy in the garden. She could put together an IKEA piece of furniture if she needed to. But now all of a sudden she's 82. She had a fall a couple of years ago. She's not quite on her game anymore. And she gets a handyman. Her kids are out of the country. One's in France. One is actually in the country, but back east. And so she does have contact with them, but you know, they call when she doesn't want to be a burden on her family. So she's lost her husband and she's at home, and this handyman starts being really, really helpful. All of a sudden, the phone line, and she had let's say she doesn't have a cell phone, she had a landline, it gets disconnected. Well, she doesn't really know how to fix it. The handyman makes it not helpful. He isn't a helpful handyman anymore. He doesn't really fix that. He instead really starts intimating in and makes himself a wonderful caregiver type person. In fact, he calls himself Sonny instead of his name. And he kind of gets Martha to really go all in. Sonny is helpful. She doesn't even notice really the phone doesn't call. She just thinks her family's not calling her anymore. So she kind of lets go, and then she kind of gets a feeling like maybe she wants to go back east and visit her son. But you know, the helpful handyman, we'll call him Harry, he discourages it. And he's like, oh no, you know, we need to do this project over here. You really need to repipe your entire house. And so she goes all in and she has some assets, but she's fumbling around a little bit. Somehow Harry gets control because now she's relying on him so much. He starts offering to pay the bills. He gets a hold of her checkbook. He takes her to the bank. She takes out a big chunk. Hopefully the bank's going to look and see that something's up. And so now there are financial institutions are putting in play a trusted person that you can add to your bank account. So if all of a sudden a large amount of money is coming out of your account, that will trigger a report and an investigation. Although again, we're understaffed, but once that gains control, and Martha is isolated, unless her family members are on top of it, or a neighbor or somebody reports it to APS or somebody comes in, Harry's got her under his thumb. And now he may very well inherit the house and isolate her, and she won't get the care she needs. And she already had the fall. So that's Martha. So let's just try and figure out and rewind and see what we could do to cut off what Harry can do. So as a professional that's dealing with seniors, or as a senior yourself, or as someone with a senior parent or somebody that's a senior in your life, you need to look out for these red flags, especially when there's a new person that's starting to control access, where you might have already gone out to brunch every Tuesday and now, you know, Martha's not really available for those Tuesday brunches, and you start noticing that Harry's kind of in the background. A sudden change in those communication habits is a huge red flag. That's something that I would suggest you investigate immediately. If there's missed appointments, social withdrawal. Now, some of that happens as seniors get older and they're in a place where they're very, you know, they have an illness or they're dealing with a medical challenge. They may withdraw naturally from social isolation, but that's when the community and people that are working as service providers need to step it up and make sure that if there is a missed appointment, why was the appointment missed? When there's financial changes and there's no explanation, that's huge. And I cannot stress enough how often I see these red flags, because I get the cases that come in when the red flags were flying and nobody got there in time. So let's move on.
Okay. We are now at our first poll question. Sudden change in communication habits may be a red flag of isolation. True or false? Sudden change in communication habits may be a red flag of isolation. True or false? Please remember that if you're looking for continuing education credit, you must answer all of the poll questions as they pop up. If you're unable to answer the poll question and using the feature in front of you, please put your answer into the chat box. Again, poll question number 1, sudden change in communication habits may be a red flag of isolation. Go ahead and share the results. Great job, everybody. I'll now hand it back over to you, Edie.
Thank you. I'm so excited that everybody was able to participate, and we're not making it hard on you, but so what we see is the seniors that are at the most vulnerable are when cognitive decline starts, when dementia is diagnosed. And of course, even when dementia is diagnosed, it doesn't necessarily mean that they lack capacity or that they don't have moments of clarity. So they become very vulnerable because in that position, when there is cognitive decline present and maybe a dementia or an Alzheimer's diagnosis, there's still a human quality where we all want to make sure we're taking care of ourselves. And so your vulnerability is increased. Bereavement of a loss of a spouse. When a spouse passes away, especially a long-term marriage where the spouses really relied on one another, that bereavement can create a huge vulnerability and make the senior very, very susceptible to abuse and isolation. Limited mobility and transportation. This is a huge factor. We need to find, as a community, more ways to bring services in to the senior, especially if they have limited mobility, coordinate transportation, and then housing and financial insecurity. That is also a huge vulnerability factor. And it's getting more and more dire as the boomer population ages and leaves the workforce, and they may be just on public assistance. So housing and financial insecurity get more and more and more prevalent. And I do believe that with housing, especially where in the case of Martha, her kids, one of them's living in France, one of them's back east, they may or may not want to bring mom into their home. And they may or may not want to move home to take care of mom. And if she just lost her spouse, she is a prime target for somebody who decides, hey, mom has a house and she has a couple of assets that I can reach into. And now Harry, the handyman, is Sunny. And Martha's sitting there all alone, thinking her kids don't want to be in her life. And because that's what Harry's feeding her. And all of a sudden, has cognitive decline and she may not actually remember, day-to-day things that are going on. So let's move on. So this is the key. It's to disrupt and prevent. So we have to have, like I talked about before, the bank tellers, they're now really on target. If you're a child of an adult, a senior that's having some cognitive decline that you really need to do the check-ins, and I would do them, it says off-hour check-ins on here, discrete contact methods, have a neighbor's phone number. If you can't get in touch with the senior, call a neighbor, see if the mail's piled up, see if it looks like the car's still there. And that's another thing, is we're talking about seniors that are starting the cognitive decline. They may or may not have given up their keys yet. And so there's also an element of what's the safety for DMV. APS welfare checks is a very good way to get in there and disrupt. One incident, I had a client call and she was very concerned because her dad hadn't been returning her calls. She was just beside herself. Well, it turns out 93, he was actually doing really well, and his daughter was overly concerned and it was annoying him. So he just wasn't returning the calls. But I told her, well, why don't you give him a call and leave him a voice message, because he wasn't returning the voice messages, and let him know that you're not to be concerned, but you're concerned about him and you're going to send a welfare check over to his house. Well, guess what? He called back right away and that was fine. But she was on top of it. She was looking at her 93-year-old dad who had lost his wife, who is having some cognitive decline, but at the same time, he's a human that has his own, he has his own agenda. and he didn't want to talk to his daughter, but that was a good way to do it. So also, if you could share financial and health monitoring, that's great. Right now, we all know there's like the portals for medical. If your parent or the senior is going to allow you to have access to either their finances or the health monitoring, that's an easy way, even if you're not in California, to go ahead and take checks and pull it up. Another thing that you could do if you start helping, say it's your parent and you start helping a senior, you can look at a TrueLink card. A TrueLink card is something that you can fund with their money, and it's a debit card that has their name on it, but it gives you the ability to kind of check where the money's being spent and make sure somebody like Harry doesn't get in there and all of a sudden there's, a $28,000 repiping of a house that didn't need it. Okay, let's go to the next slide. And we have a poll.
Poll question number 2. Bereavement is one factor that can lead to vulnerability of an elderly. Question number 2, bereavement is one factor that can lead to vulnerability of an elder. True or false? And again, if you're unable to answer the question via the poll, please do put your answer into the chat box. Bereavement is one factor that can lead to vulnerability of an elder. True or false? Give it just a few more seconds while everybody gets a chance to answer. Bereavement is one factor that can lead to vulnerability of an elder. True or false? Go ahead and we will share the results. Great job, everybody. And now back to our presentation.
So now I am going to talk about anti-isolation restraining orders. These are now readily available. They are a great tool. If there is isolation, you're afraid of tipping off the bad actor, bringing an anti-isolation restraining order is something that could really be helpful. The laws changed in 2023 and made this possible. So there are judicial council forms online, and they're pretty easy to fill out. So in one case, let's just keep Martha going. Her neighbor, Randy, realized that she wasn't taking out her garbage anymore, and he didn't see her, and he wasn't able to see her. And then all of a sudden he's being blocked from access to her by Harry. He can file an anti-isolation restraining order as a friend, as an interested person is what it's called. So as an interest in pretty much anybody that has a relationship with the senior can file an anti-isolation restraining order. What you're going to have to prove is that there is a proactive restriction of your visitation, and it's not due to the senior not wanting to see you. So what happens once you file an anti-isolation restraining order, there are notice mechanisms. So you are supposed to notice the senior, you're supposed to notice everybody. You can actually do ask the court to restrict the notice until after the restraining order is looked at by the court, and the court investigator will go out, and a court investigator will assess and report to the court on the isolation. But it is a really good tool. So it did come into effect January 2023. Standing just means who can bring it to court. So in the past, it was only the elder or the dependent adult. I think there was, there were some famous cases where the elder didn't want the son to contact anymore. It opens it up now. So they used to be really limited in scope. Now, the big thing about the new anti-isolation restraining order, it's really about disrupting and getting rid of this vulnerable tool that, Harry the handyman or anybody else is going to use to isolate. And it just takes eyes and ears. It takes somebody who is friends with, or a neighbor, a family member. So even a family member back east if they can't get in touch with mom and they start getting panicky, they can bring an anti-abuse, anti-isolation restraining order, and that can allow access and disrupt this whole process. So just to recap, they're available since 2023, and family, friends, neighbors, interested parties, they can file. It doesn't require proof of abuse, only repeated interference. So you don't have a higher burden to prove to the court. And the court has to assess the elder's capacity and the desire for contact. That's where the court investigator comes in. And that's where there is, again, if there is an abuser in there, it is going to disrupt the pattern. It's going to put eyes on them, and it's going to make a record. So the next tool I want to talk about is supported decision-making plans. Now, SDMs. This also got codified. So, and when I say codified, I just mean it turned into a law. So prior, it a little bit had to do with Britney Spears. There was a lot of law changes that came in on conservatorships. Conservatorships are a heavy lift for the court. They take up a lot of time and consumption. And part of the thought process is if a person can make their own supported decision-making plans and they're done prior to any kind of slip in cognitive abilities, and it's written down, it is such a brilliant tool. So let's go to the next slide. So there is this CDM tab, and it's a assistance program, and it can help guide how to do these things. Also online, you're going to be able to find different types of formats. And now it's also in the law, so that when we're talking about supported decision making, what it's really doing is you go to the senior, and if you're a provider, a service provider of a senior, and they're struggling and they don't have a lot of people, they don't have family members that are actively advocating for them, I think it's a good tool to be able to put in front of them and discuss with them, hey, if somebody needed to make your housing decisions for you because you couldn't make them, you could obviously make them now. And this is not something that is going to take away any of your rights right now at all, in no position. This is something that allows the person to make decisions while they have cognitive ability and can say, yes, you know what? I really trust Sally, my neighbor. She will look out for me. We've been best friends for 40 years. I want her to make my housing decisions. Now, maybe this person, we're talking about a person who doesn't have children and doesn't have close family members around them. So they're picking a friend. The next step on that is for the friend, Sally, needs to sign off on it. She needs to know, hey, Barbara over here is tapping Sally to be her decision maker. Are you okay with it, Sally? And Sally will have a conversation. It really opens it up so that the senior can start looking at what is their support mechanism and what is the fabric, the safety net that they have in case they do lose cognition. And it should be presented very early on. If we could go to the next slide. So everybody in California under California law is presumed to be competent and have the capacity to make decisions unless there's a legal proceeding to deem them incapacitated. So a lot of times you have competency is like a big litigated, when did they lose competence? And that kind of goes into an undue influence legal framework. But with the supported decision making, every adult is presumed to be competent. Now, with these agreements and arrangements, we absolutely want to make sure that they have competency, that they're really thinking it through, and they're not already isolated and dealing with Harry the handyman and they want him to make all the decisions. That could be a problem. If you are counseling, and anybody can get these supported decision-making documents done, it doesn't require a lawyer per se. You don't have to have him drafted, and it's not evidence that they lack capacity or that they need a conservatorship. It's a preemptive thing that says, hey, you're great right now. Let's look at your safety net. Let's make a plan for your safety net, and let's do it now instead of at a time when you're not able to do it. So that's the big key for this, is that you really want to approach it as it's a personal choice, and it's really taking an inventory on what are your support systems, what are they in the world. And if you don't have one, and you're making this, say you're doing your own supported decision making, because none of us know if we're going to be in an incapacitated position at any point in time. It could happen to anybody. So one of the things with the supported decision making is you really want to look at your landscape and who you're going to make decisions, and write it down and talk to that person. Also, I want to add that if there is a question that there's already isolation happening, it's really good to check in and see if there is family members kind of in the mix, and get that out on the table and let them know, hey, there's a supported decision-making agreement being done. Okay, let's go to the next slide.
Okay, our next poll question. Supported decision-making takes away the full legal authority to act on behalf of an elder. True or false? Supported decision-making takes away the full legal authority to act on behalf of an elder. Once again, if you're unable to answer the question using the full true or false box, please do put your answer into the chat box. We'll give it a couple more seconds. Supported decision-making takes away the full legal authority to act on behalf of an elder. True or false? Okay, we'll go ahead and close the poll. Yes, the correct answer is false. And now back to our presentation.
Terrific. So I just want to highlight, as I'm on the end of my presentation, the problems that I see are incapacitated individuals who haven't done pre-planning. That is the biggest problem. And pre-planning, executing the requisite documents, which Kelly Morris is going to be talking to you more about. This is where it's really important that pre-planning is done, either by a supported decision-making agreement and or by the estate planning that Kelly's going to talk about in the next presentation. But this is going to allow for an alternative to conservatorship, because now in California law, they're looking at the least restrictive means. The conservatorship can only be put in place if it is considered the least restrictive means for the individual to be legally cared for. So if there are proper documents in place and a support system already embedded before the person loses capacity, that is the key. Now, one thing I want to talk about is when somebody doesn't have family members or trusted people in their life, a good thing to do is, just like you're getting a quote for your pipes and you should get 3, you get a quote. Instead, you meet with 3 different professional fiduciaries. You should look probably at their ages, and a professional fiduciary can come in and at the time of incapacitation come in and take care of finances, make sure the elder has the care they need and the proper support that they need. So that is one good thing. So let's move on to transition to estate planning. Like I just said, I think an SDM, a supported decision-making, is a very positive step. It's going to tee them up to have at least that conversation and the thought process of, who am I going to get to take care of me? And the thing that we all know is, with our example, Martha, she doesn't want to be a burden on anybody. So she may not even want to think about, oh, I don't want to burden my daughter. I don't want to burden my son. But look, if Harry's standing in the wings and he's going to swoop in and just disrupt everything and isolate her and make the end of her life awful, that is not okay. So having these conversations may stimulate and open it up to, maybe I do need to look at interviewing some, talking to my daughter, or talking to my son, or interviewing some professionals. We absolutely, as a community, all have the power to bring anti-isolation restraining orders. We need to keep a lookout for the warning signs. Don't let it go too long. If you see something, you need to say something. And I think these are just tools and strategies to prevent elder abuse and avoid conservatorship. I think that if we keep our hearts open as a community, we can see when there's somebody struggling. And, more than ever, I think we need to have compassionate hearts and don't look the other way, because the isolation, especially post-COVID, it's been really, really troubling. And it's put people, they're stuck in their houses watching, some terrible news on constant, and then they become sitting ducks for vulnerability and elder abuse. So that's what we're here to do, is prevent it. And I just want to thank you all. I have a couple of questions that I want you guys to think about. And that is basically, what's going to happen to elders who are vulnerable to undue influence? What happens to them? Think about it. Think about the seniors in your life and the elders in your life. If they're vulnerable, what could happen? What's the worst outcome? It could be really dire. And it's, unfortunately, my litigation practice is extremely busy right now. And it's because there is so much undue influence and vulnerability that is being acted on. And I don't like that. So I want you to think about that. And then, do we think that financial institutions are going to honor the supportive person? That is a big open question. I think a supportive decision-making document is not going to be adequate enough. So that's why when Kelly talks in her presentation, she's going to give you some more tools. It is the financial institutions that are very difficult right now. And yet, at the same time, sometimes they look the other way and awful things happen and whole, life savings disappear. So with that, I want to open it up to questions.
Edie, thank you so much for that terrific presentation. And I'd like to introduce Tracy from Alzheimer's OC, and she'll assist our audience with the Q&A section.
Thank you so much, Libby. So as a reminder, questions and comments can be typed into the Q&A box seen on your control panel. And we will now take questions for Edie, and we already have a lot coming in. So first, I just want to start with some comments from Diana. She mentioned that home delivered meals isn't possibly another safety net if drivers, or I should say the drivers are maybe familiar and maybe notice some of those changes over time, and they might be able to be reported and possibly prevent more damage. And she also shared another safety net is utilizing the Older Americans Act case management programs, which offer home visits and monitoring. So thank you, Diana, for those comments. So I want to go into the first question. Edie, you mentioned a debit card. What was that debit card again?
That was called a TrueLink card, and a lot of the professional fiduciaries use them, or trustees use them. And so I was just suggesting that as possibly an adult child's tool for their parent who's seeking to remain able to shop online, but there's some more access, so you can turn on and off switches, but it's called a TrueLink.
TrueLink. And any special spelling with that?
It's all one word, TrueLink.
Perfect. Thank you so much. And then we have a question from Kathleen. Is the anti-isolation restraining order California specific or nationwide?
It's California specific. And so if you're online, you can look at Judicial Council, COUNCIL forms, and they're, I think it's the EA 300. So there's forms specific to anti-isolation.
And then is the supportive decision-making being generated by adult protective social workers? And this was a question from Diana.
So I don't know that they're being generated, but I do speak on the FAST team, and I do think it's a really helpful tool for an APS worker to possibly suggest a supportive decision-making agreement or look at the supportive decision-making agreements that I think the ACLU has one online that's pretty robust, just to go through the questions, because these are things that I think APS should be finding out anyways. Who's your support network, right?
Okay, thank you. And then next we have Jordan. Is formal training for mandated reporters available? Any required frequency in updating the training?
I don't know that specific answer to that question. And there must be, and I would think mandated reporters, depending on if you're a financial institution or you're a therapist or you're whoever you are, I would think your organizations would be specific in it and provide training.
Okay. And then Kimberly asks, what is the time frame the court investigator must visit the elder in a restraining order?
So typically it's within the first 5 days. They are short-staffed, it seems to me. So as this anti-isolation is more and more used as a tool, it could get tricky. So I don't know the exact time. I do get frustrated at times with the court timeline. And it's because there was such a decrease in funding that the courts aren't robustly funded. So it's kind of a chicken and the egg, but there are timelines and guidelines that they have to follow.
Okay. And then from Leland, they ask, I saw before the beginning of the seminar an outline of contacts and information from Council on Aging and also Alzheimer's Orange County. That can this be sent to us who are on live? Yes, of course, we can share that with you. And for Alzheimer's Orange County, we do have a helpline that's available Monday through Friday from 8:30 to 5. And that number is, if anyone has a pen or a pencil right now, 844-373-4400. Again, that's 844-373-4400. Or if not, the slides will be sent out as well. All right. The next question is from Vivian. What if the abuse has already caused the person to lose the house? Is it about 10 or more years? And it has been about 10 or more years ago, this individual says.
So that's a good question, because it depends on a number of factors. That's where you're going to have to contact an attorney to really look at the statute of limitation issues. With financial elder abuse, specifically in California, there's a 4-year statute of limitations from the time the elder, and if the elder's deceased, the next of kin finds out about the financial elder abuse. Now, of course, if 10 years has gone by, it's going to be harder and harder to unwind. It doesn't mean it's impossible to unwind. I have a very complex financial elder abuse case that that happened 8 years ago, and it wasn't discovered until 5 years after, and then the suit needed to be brought. So there's very technical statute of limitation issues and things of discovery. So hopefully that answers your question, but I do recommend you seek out an attorney that specifically deals in financial elder abuse.
Thank you. And then Kimberly asks, are court investigators required to meet the elders privately, meaning without their power of attorney?
Yes, they are. And so there has been instances where I've seen court investigators blocked, and that the sheriffs had to be called in. But yes, they absolutely have the power, and they need to speak separately. If they're being blocked, they will put it in their report, and that will, of course, go against the bad actor.
Perfect. And then Kathleen asks, how can we prevent or how to prevent disrupting a spouse who is the bad actor The durable power of attorney, financial and healthcare family members are out of state.
So again, that is a question for an attorney to answer, and there are procedures. You usually will have to go to court to disrupt that, and especially if the power of attorney is a spouse, and the spouse is now taking advantage and draining out. They put the cognitively disabled spouse in a nursing home, and they're gutting. And what I see, and again, I see this a lot. It's in blended families. There may be a second wife, or kids from different families that are noticing this, and it's stepmom or stepdad that's doing the bad acting, but they have power of attorney, and at some point the spouse trusted this person to do this. There can be actions that are brought to preempt it, and I always say get in early. The more transfers, the more likely you're not going to be able to transfer things back.
Thank you. And then Lynette asks, what is the difference between a power of attorney and supportive decision making?
So I'm going to leave that for Kelly to discuss, because her presentation is going to discuss the power of attorney. But one thing, the supportive decision-making agreement is a newer tool, and it's more robust in that it's talking about who do you want to make your decisions for, what clothes you wear, what people you see, what house you live in. So the uniform statutory power of attorney is something that Kelly's going to discuss in her next presentation.
Perfect. Okay. And then Hannah asks, what legal proceedings must be done to declare someone incompetent?
So that would be a conservatorship action. And that is a process where somebody petitions the court. There's two types of conservatorships. There's conservatorship of the person and conservatorship of the estate. And then there's powers for dementia that come into play as well. But that is a proceeding, and I'm not going to talk too much about the power of attorney side of things, but there are a lot of documents that trigger when incapacity of somebody that, say, is a trustee of a trust, and they become incapacitated. You don't necessarily have to go to court for that. It will say in the trust document, it generally says two doctors, one the primary physician of the person, but it's always something written in the document. Otherwise, you're going to court and you're having an assessment done. And if it's uncontested, meaning nobody's fighting over it, and everybody in the family's like, wow, mom never did anything, we don't have anything, we need a conservatorship over her. Hey, Johnny, we want you to be the conservator, and everybody's on board. It's an easy process. What I typically see are, maybe the bad actor wants to be the conservator, and the children are like waking up to the fact that mom's been taken over by bad actor. And so there's a dueling conservatorship. And say bad actor got somebody to write up documents to say that they're nominating him as conservator. That's where it really gets ugly. And so those could be long and drawn out.
And then I'm watching our time, so hopefully we have a few more minutes for questions. But Kathy asks, is the supported decision making legally recognized in the state of California like a power of attorney?
It is. However, what I'm seeing is that financial institutions are resistant. In fact, they're even resistant to regular power of attorney. They want their own form. And there's actually a code that you can go against the financial institutions because they need to accept uniform statutory power of attorneys. However, the supportive decision making is a legally valid document, and it is codified. So it's still difficult because people want to make sure they're not liable for certain things. So they're going to require additional documentation.
And then Just looking at our time, we might have a question or time for one or two more questions.
Just to follow up on that, I just want to say that the supportive decision-making is legally recognized, especially as a least restrictive means to a conservatorship. So if you're in a conservatorship realm and mom has already said, hey, I want son to take care of all of my finances and I want daughter to make sure that I'm doing all these things, that's where it's really great, because that would be deemed the least restrictive means, is to have the family members continue on in their path. And it could be in a conservatorship, like somebody's trying to bring a conservatorship, and the SDM is looked at in that realm.
Thank you for clarifying as well. I saw a question. Okay. All right. Let's see here. Apologize, I lost the question. I will ask this last question here. What is the average cost of conservatorship fees in Orange County?
So there's a $435 fee to file for conservatorship, and you have to electronically file. So there's those type of things. Those are the court fees. They can also be waived if there isn't enough resources for the person who's proposed conservatee to pay. However, it's the legal fees. If you're going to have an attorney do it rather than going in pro per, it varies widely. So I don't want to quote fees, but I can tell you this much. It's going to be, if it's a straightforward garden variety, it's going to be one set fee. If you get into a contested litigation, I've seen it go into the hundreds of thousands of dollars, depending on who's fighting and what they're fighting over.
Well, thank you so much, Edie. And I do see we still have a few more questions in the chat box that we did not get to, but Edie will be here for after Kelly's presentation. So it's something that we could hopefully get to some of these other questions. If not, we will compile these questions for our presenters to send out and answer an email to everyone who attended. And also, again, thank you so much for your presentation and all of your information. But next, I'd like to bring back Johanna to introduce our next speaker.
Thank you, Tracy. Our next speaker of the day will be Kelly Morris. Kelly Morris is the director of the Council on Aging Southern California Senior Protection Program, where she provides education and outreach and limited public consultations regarding elder abuse. Kelly is also the chair of Orange County's Financial Abuse Specialist Team, FAST. FAST members serve as volunteer advisors, offering information in the areas of law, criminal investigation, civil litigation, guardianship, banking, accounting, real estate, insurance, and senior services. FAST assists Adult Protector Services, APS, the ombudsman, law enforcement, and attorneys in resolving complicated matters of abuse. Kelly is also the co-chair of the Orange County Strategic Plan of Aging Elder Abuse Subcommittee that ensures a coordinated response and messaging in elder abuse education in Orange County, and plans and hosts the annual World Elder Abuse Awareness Day, which we're in right now, event held in June of each year. She also served on the advisory panel of UCI's Center of Excellence on Elder Abuse and Neglect for the Ending and Disrupting Elder Abuse Recidivism Project. Additionally, Kelly serves as a Social Security Disability Appeals attorney and represents individuals throughout the United States to obtain federal disability benefits. Kelly has a BA in Biological Sciences with an emphasis on genetics and a minor in psychology from USC, and a Juris Doctor and Masters of Small Business Law from Conrad Law School at Purdue. Please welcome Kelly Morris.
Good morning, everyone. Thank you, Johanna. I appreciate the introduction. That was a lot. Edie just spoke to us about supported decision-making plans and anti-isolation restraining orders. And those are tools that help you remain in control of your life and your decisions and your relationships. But what happens when we're no longer able to participate in those decisions or make decisions in our own best interest, even with the support of others. We'll need to fill our toolbox with other tools, and those other tools will allow us to choose individuals to act for us and continue the plans we have for our future. So what I'd like to do first is talk about, excuse me, just the general benefits of planning for the future. So the main plus for any of us who are doing the planning is it really lessens the stress and anxiety, and it improves both our emotional and physical well-being. So it alleviates our fears about what will happen to us when we become unable to manage our own affairs. It allows me to be involved in the front end, so I get to choose the people who are going to take care of my affairs when I'm no longer able to do so. It also allows me to indicate what my wishes are, right? What do I see for myself in the future? Even if I have dementia, where do I want to live? What kind of friends do I want visiting me? How much money do I want spent on my clothing, even if I'm in a facility? It also eases the anxiety of those who love and support us. And this is a really important point because the plan provides directions to follow so that the people who love us and who take on this responsibility do not have to make hard decisions about life-sustaining care. They'll know that I don't want to be kept on life support, and it makes it less emotional and less difficult to take me off of life support because they know that's something I'd want. It makes it easier to sell a family home or a vacation home that's been in the family for years to take care of the cost of my care. It also helps me think about asset distribution, right? How do I want my money and my assets used if I'm no longer able to manage those things? And finally, it actually will help secure my assets against fraud. As an example, excuse me, it is much more difficult to change the title on a piece of real estate if it's in a trust than if it's outside of a trust, because now you have to have a trustee signature. And hopefully I've identified maybe even a trust protector if I am the trustee to make sure that I'm not doing something foolish. And Edie touched on capacity, and capacity is probably the number one issue in most abuse cases and in most conservatorship claims, right? So there are many types of capacity, and we're just going to focus on a couple today. But for example, financial capacity is the ability to manage your money and assets in your own best interest. You reach a peak point at some time when you're an adult, and then as we get older, that ability naturally begins to diminish with age. And so we start to experience diminished financial capacity, which is the decline or loss of the ability. And again, that loss can vary. There may be someone who's 106 who still has 90% capacity and is able to manage all of their assets and affairs. And you could also have someone who has very little capacity by the time they're 65, maybe due to disease process, maybe due to a traumatic brain injury. But in any case, we have to expect, and this is why we have to do planning, that at some point we're going to face this issue of diminished financial capacity. The most important form of capacity or type of capacity is legal capacity. And as Edie previously discussed, in California, everyone is presumed to have capacity to make decisions in their own best interest until a court of law determines otherwise. It's also a very complicated process because the law in California is not particularly straightforward. So the presumption of capacity, of course, is beneficial because it really preserves the people in California's right to self-determination and autonomy until a court says otherwise. So, as an example, there could be a doctor who says, I'm no longer able to make my own decisions. And that would trigger, let's say, someone who's named as my agent or representative under a power of attorney to start acting in my best interest. However, I can contest that, right? Because in California, I'm presumed to have capacity until a court of law says otherwise. So while that doctor's opinion might be very persuasive evidence in a court proceeding, it does not ban me from having capacity. It is not the ultimate statement as to whether or not I do have capacity. So again, this is a very beneficial for all of us. But this presumption can also be very harmful. It allows people to continue to make decisions, even bad decisions. And that, of course, increases our vulnerability to manipulation or scams. Because if we think that we're on top of our game, but we're really not, but we're presumed to be on top of our game, then it allows people who see that we're not on the top of our game to come in and take advantage of us. So it can be a risky proposition. And when I say that capacity is complicated, what do I mean by that? So in California, capacity is based on a spectrum of ability, so that an individual may have the capacity to do one thing, but lack capacity to do another. And the required capacity to partake in a legal action depends on the action itself. So, as an example, someone can have early stage dementia and still have full capacity to manage their own affairs, including entering into contracts, right? Buying a car, selling a house. Then they may move into a stage where they have mild dementia and maybe they're forgetting to pay their bills. And so they might need some reminders to help them pay their bills, but they still retain most of their capacity. They then might move into a moderate stage of dementia where they can still manage their day-to-day affairs, but maybe they shouldn't be purchasing a car because they don't understand the implication of that contract that they're entering into. And then, of course, there's very severe cases of dementia or incapacity where people do not have capacity to do much of anything and really need, excuse me, someone else to make most of those decisions for them. And just so you know, determining who should inherit your money, who should manage your medical care, who should decide where you live, you don't have to have a lot of capacity in order to do those things. And so in any case, when there's a question about capacity, a court has to take a very deep look at you and your abilities, and on this spectrum, decide whether or not you're partially incapacitated, totally incapacitated, and if you're partially incapacitated, what things can you still do? And so it can be a very complicated process. And as Edie said, it can get very expensive because a lot of work goes into this determination of capacity, especially when there's a conservatorship petition that's been filed.
Now, time for our fourth poll question. In California, capacity is based on a spectrum, much like autism. True or false? In California, capacity is based on a spectrum, much like autism. True or false? And again, if you're not able to answer the question using the poll box, please do put your answer into the chat box. In California, capacity is based on a spectrum, much like autism. Give it just a few more seconds so everybody has the chance to answer. Again, if you're looking for CE credit, you must answer all of the poll questions as they pop up. Okay, go ahead and close it out. Great job, everybody. The answer is true. And now back to our presentation.
Thank you. And I do want to apologize for my voice. I'm having some vocal cord issues, so it's irritating to me. So I apologize if it's like nails on a chalkboard for all of you. So let's talk about some of the tools that we can use to do some kind of future planning for when we're not able to take care of ourselves. Going to talk about just 3 things, and we're not going to get into a deep estate planning conversation today. I'm going to talk about these tools in general and the purpose that they serve, so that you have some idea of the minimal things that you should have in your plan. We're going to talk about wills or trusts, distributing your assets during your life and at death. We're going to talk about powers of attorney that allow you to appoint someone to manage your property, your assets, your person or personal care. And we're going to talk about advanced healthcare directives, which allow someone to manage your medical care. So the main difference between a will and a trust is that a will only acts or takes legal effect once you pass away, and it allows the distribution of your assets. A trust, on the other hand, can be something that helps manage your assets while you're alive, and then it can also direct distribution of your assets after you pass to your beneficiaries. And here is a side-by-side comparison of a will versus a trust. And as you can see, the differences are many. For example, under a will, you can actually designate a guardian if you pass before your children become adults, right? So you can designate someone to take care of your minor children. And a trust cannot do that. It does not designate a guardian for minor children. So you have to have a will and a trust. But the main thing that the difference, which is what most people determine whether or not they need a will versus a trust, is that a trust actually provides protection against conservatorship, and it eliminates the need to go through probate court. And again, a will provides no protection against conservatorship because it's not valid until you pass away. And you obviously don't need a conservatorship after you've passed away. So a trust can be a really important tool in helping to protect your assets and protect you from conservatorship. If you've already designated someone within the trust, the trustee, to manage your affairs, then that takes care of any need for a conservatorship. As any legal document, a trust can be contested, and someone could bring a conservatorship petition anyway. But this is very, again, persuasive evidence in a court of law that you've already thought about things, and these are your wishes. And as Edie indicated earlier, under new California law, the court has to consider what your wishes are, and that a conservatorship would be less restrictive than the terms that have already been defined in your trust. So trust can be a really important tool in avoiding conservatorship. Again, a trust, if you move your assets into a trust, it's also more difficult for somebody who's trying to exploit you financially. It makes it more difficult for them to get at your assets because now they belong to the trust. They no longer belong to you individually, but they're assets in a trust. And so if you have a lot of money or a lot of things that are very valuable, it's really a good idea to get a trust in place. At the very least, you should have a will to determine how your assets will be distributed when you pass away. So that, for example, if you have a favorite doll collection and you know that your niece really has a great deal of affection for that doll collection, you can pass it on to your niece and you know that's where it's going to go. And that, of course, once again, gives us some emotional comfort to know that we've got our ducks in a row. So let's first talk about power of attorney again in a very general manner. So what is a power of attorney? So a power of attorney is a legal document that allows another person to make financial or other decisions on your behalf. It can be a general power of attorney, meaning they have the right to do anything and everything, or it can be very specific, saying, I only want them to pay my bills, pay my health insurance, and make sure that my life insurance is paid. It can also be very specific about what kind of life decisions that person has the right to make. You can say, I want this person to make sure that I am able to continue attending my brunch with my coworkers that I worked with for 25 years. We meet every Sunday. I want to make sure that that is continued, and I want this person to make sure that that continues. But I don't want this person to decide who I visit with and who I can see on a regular basis. Why do you have a power of attorney? Well, the point of putting a power of attorney in place is it allows you to choose a trusted person to do all those things. If you don't have a power of attorney and you're determined to be incompetent, then the court gets to decide who's going to make those decisions for you. And it may not be a person that you would have picked for yourself. And in fact, if there's a family feud and your family members are in disagreement about which one of them should become your conservator, then the court will appoint an independent person. And again, that person may not honor your wishes. They just have to act in what the court thinks is your best interest. And ultimately, that can really strip you of your autonomy because the court decides, right? You've taken the decision out of your own hands and given it to the courts. And when does a power of attorney become effective? Well, you get to decide. You can give the power of attorney and your agent immediate action, meaning it is effective immediately, or you can say it's going to be triggered, as Edie discussed earlier, upon the happening of particular events. Again, it would require that two doctors indicate that you're no longer able to care for your own affairs, and thus it triggers the power of attorney. And I just want to say, and a lot of people don't know this, even if two doctors say that you're no longer competent to manage your own affairs, remember, you can contest that. It doesn't have legal bearing. You are presumed to have capacity until a court of law says otherwise, and you can always revoke a power of attorney. If you think someone is trying to take advantage of you and you think they've shopped around and gotten these doctors to say that you're incompetent so they can have access to your money, you have the power to revoke that power of attorney and name a new agent and or take over your own affairs again, assuming that you have the competence to do so. And in choosing your agent, this is the most important thing about supported decision-making plan, a power of attorney, a healthcare directive, which we'll talk about in a moment, a trustee. You want to choose someone you trust. And when I talk about trust, I'm talking about someone you trust to follow through with your wishes as they're stated in these documents, and someone you trust to use your money and your assets in your best interest, not their own. You can always designate more than one person. You can have a power of attorney for this and a power of attorney for that. You can have a successor. So, for example, if I identify my dad to be my power of attorney and then he passes away, there's already a successor in place. And if I've become incapacitated between when my dad passed away um, and the new person took over, they don't have to ask if I had capacity to name that successor agent because I've already done so when I had capacity when I first drew up the document, the power of attorney or trust or whatever the document is. You also want to make sure that that person is financially sound. Within families and friendships, most people who manage other people's money start out with really good intentions. And they don't have any intention to take money and use it in their own best interest. But a single catastrophe could cause someone to make a bad decision. For example, let's say I'm managing your money and my spouse loses their job and we're suddenly strapped and I don't want to lose my house. We're 3 months behind in the mortgage now because my spouse has not been able to find a job. I have access to your bank account, so I figure I'll borrow the money and then I'll pay it back. And then by the time my spouse gets back to work, I realize that we're so far in debt, I'm never going to be able to pay that back. And I didn't intend to take that money. And when I did take it, I intended to pay it back. But now I'm in a position where I'm not going to. And so you just want to make sure that the person that you choose has some financial stability. They have some savings and some assets that they can draw upon should some kind of financial emergency arise in their life to avoid any bad decisions. You also want to make sure that you avoid high conflict personalities. What do I mean by that? People who tend to be argumentative, who have to be right, who don't want to listen to input people, and actually think that other people are not smart enough to provide any kind of advice or input. People within your family who have issues with all your other family members. The last thing you want to do is put someone in charge that's going to cause a huge amount of conflict, either amongst your family members or friends, or even amongst professionals. So you want to make sure that you're thinking about the personality of the person that you're putting in charge. And then finally, you want to make sure that the person you choose understands and is willing to accept the responsibilities that come with being a power of attorney, as well as their fiduciary duty or responsibility to act in your best interest. People think this is a great thing to be identified as someone's power of attorney, right? To take over in the future should they become unable to manage their own affairs. Take it from me, who has settled many an estate. It is not a fun job. There are a lot of legal ramifications. You can get in a lot of trouble if you do things the wrong way, if you don't provide, accountings, or if you're not being transparent to other family members who then can allege that you're financially abusing your parent. So you really need to make sure that people understand what they're getting into, and that they actually have the skills to handle the task that you're identifying them to take on. So the fiduciary duties that I just mentioned, the person has to act in your best interest. They have to retain records, so if there's any question about what's gone on, they can show, written evidence of what they've been doing. And they need to stay in contact with you, right? And you need to make sure that the person that you're naming, especially if it's a professional rather than a family member, you need to make sure that you have a relationship with that person. And as your ideas and plans for the future change, that you alert them as to the changes and the differences from when you last spoke to them or when you first named them as your agent. And there are several tasks that fall under a power of attorney. Your personal care, where you live, hiring household employees, for example, caregivers, and then, of course, asset management. So they're going to have access to your financial accounts, pay your bills, file and pay your taxes, and they can also manage your contracts. Again, things like life insurance, health insurance, making changes to your Medicare plan every year, um, uh, which will also fall under a healthcare directive, but they can be in charge of the financial aspect of any changes to your health insurance plans. And finally, we're going to talk about advanced healthcare directives. And the advanced healthcare directive grants power to another person to make medical decisions on your behalf. Again, why would you want one? Because it allows you to choose a trusted person to help manage your medical decisions when you become unable to do so. And without one, again, you may need a conservatorship. If there is a disagreement about what kind of care you should have, especially among your family members, this creates a problem. Well, no, mom would have wanted this. Well, no, mom would have wanted that. Well, I'm going to petition the court for conservatorship because I think I know best. So you're better off to make a choice while you have capacity and put someone in place to manage your medical decisions, rather than leave it to the courts. Again, do you want the courts to decide? Do you want the doctors to decide what happens to you? Do you want some obscure cousin, third cousin in Minnesota that the courts have managed to track down to make decisions on your behalf? Probably not. And so it's really important. Again, like a power of attorney, an advanced healthcare directive can be effective immediately, or it can happen upon the happening of certain events, and you can indicate that. And the nice thing about an advanced healthcare directive is it does let you give instructions for very difficult situations. For example, if I'm having chemo and I become really frail, and I'm unable to continue my treatment, but I'm also not willing to stop treatment, and maybe you recognize that I'm really not in a good space to make a decision about continuing my treatment, then you may have the power to step in and help me make a better decision, or speak with my doctors to say what's the best situation here and what's the best outcome. And most importantly, an advanced healthcare directive applies to everybody, as does a power of attorney, but in particular an advanced healthcare directive, because I could leave today's event and get in my car, get in a very severe motor vehicle accident and have a traumatic brain injury and not be able to speak for myself. And if I don't have anyone to identify me and I'm taken to a strange hospital where no doctor knows my records or my family, someone, complete stranger, a medical team is going to decide what happens to me. And again, if I have an advanced healthcare directive, at least hopefully they'll be able to contact my primary care provider through my insurance, and my primary care provider will have a copy of my advanced healthcare directive, and they'll be able to contact my agent. So again, this applies to everyone at any age. So on top of making decisions about treatment, an advanced healthcare directive representative also has access to my medical records, and they decide who they share those records with, right? So it's really important, again, to pick someone who's going to update other family members so they don't feel like, I had no idea mom was in the hospital. Why wouldn't you allow me to see that? And I really would like to see the records about her cancer and what kind of progress she's had with her treatment, right? So you want to get someone who's going to be transparent and is willing to share those medical records. Again, agree to say no to, change, stop, or choose doctors, medications, tests, treatments, CPR, dialysis, um, um, also end of life care, right? Spiritual leaders. Do I want to have my priest come in at the end of my life before you take me off of life support? Do I want to be at home when I pass away? Would I prefer to be in a hospice facility because I don't want to burden my family with being at home? Um, Again, I get to identify all these things and take the onus of making those awful decisions off the shoulders of my family or my designated representative. And then you can also designate what happens to your body after you pass away. What do I want to happen? Do I want to donate my body to science? Do I want it to be buried per the instructions in my will? Do I want to be cremated? I can also indicate what I want to happen with my body when I pass.
Okay, now time for our fifth poll question. The Advanced Healthcare Directive grants power to another person to make medical decisions on your behalf. The Advanced Healthcare Directive grants power to another person to make medical decisions on your behalf. Again, if you're not able to answer the question using the poll quiz feature, please do type your answer into the chat box. The Advanced Healthcare Directive grants power to another person to make medical decisions on your behalf. Okay, we'll go ahead and end the poll and share the results. Great job, everybody. The answer was true. Now back to our presentation.
Okay, and now the most important point today. Having a plan has absolutely no value whatsoever if no one knows about it. So once you've taken the time to put a plan in place, it's important to share it with your family members, your doctors, and other trusted individuals and professionals as appropriate. And sharing is important, especially with your family members, because it allows them to ask questions and gives you the opportunity to explain, for example, the reason for your choices. Um, if you have a son who is your oldest child, but he is an artist, and although he makes good money, he's not really good at managing his money. Just because he's the oldest son doesn't mean that he should necessarily, right, be your power of attorney. And he may have questions about that. Well, I'm the oldest. Shouldn't I be managing your affairs when you're no longer able to? Well, this gives you an opportunity to let him know why you chose someone else. Or if you've decided not to choose anyone in your family and instead you've chosen a professional, you can explain to them, hey, look, this is not an easy job and it's not fun. And actually, I'm saving you from the burden of having to do all this while you're grieving, either my loss of capacity or even at my death. I've just kind of taken care of all of this for you, and we have a professional in place. And it really gives people a chance to understand where you're coming from, and it actually makes it easier for them to honor your wishes. This is in particularly important if you have more than one child and your children cannot agree on things. There are a lot of long-standing emotional family things that have been around since childhood that we sometimes don't get over as adults. And those can be really problematic if someone has to step in and take over your affairs. So having a conversation helps kind of squelch that. You know, listen, I know you guys don't agree on this, but here's what I've decided to do. And I really, instead of selling the family home when I have to go to a facility, I want to sell the vacation home. And John, I know you really wanted that vacation home, but I'm sorry, that's going to have to be sold for my care should that come up. I would rather hang on to the house. And John, you'll get your percentage of the house and you'll get your percentage of any of the money that's left over from the sale of the vacation home. But this is the choice that I've made. It may also be the case that you're on a second or third marriage and your children don't agree with your current spouse, right? About what kind of care you should have. Let's say your current spouse is, well, I don't think that, she should continue with this chemotherapy. It's just making her sick. And your kids are saying, no, I want her to continue as long as she's willing to because we want her to be around as long as possible. So again, having a plan and letting people know up front, this is what I want, and these are the people I want to make those decisions, and then explaining it to them and your reasons why can be very helpful and can avoid a lot of in-family feuding. And it also triggers conversations about distribution of assets when you pass, right? As we talked about earlier, if you let somebody know about a plan, for example, the doll collection I talked about earlier, if I let my family know, hey, listen, Stephanie really wants that doll collection, and so I'm going to give that to her now or in 10 years or when I pass away. And let's say my daughter Jan comes over to my house and says, hey, where's your doll collection? I thought that you were going to pass that on to Stephanie in 10 years. And I tell you that I met a friend at church who's been helping me sell things on eBay, including my doll collection. This might trigger you to ask me, what's going on? Maybe someone is financially exploiting me and maybe they're keeping, 50% of my money. And this is actually some kind of scam, some kind of trick to get in and start taking advantage of my assets. And as Edie indicated earlier, build my trust, get me to let them into my life so that at some point they can take even more valuable things from me. And so planning also has a protective aspect in that if I tell you about my plan and you know what my plan is, and I'm suddenly not following that plan, it should at least trigger you to ask some questions and hopefully get in there and disrupt that chain so that I avoid any abuse or any further abuse. Okay, and that's it for me today. And I guess we will move back to Tracy and on to our questions.
Thank you, Kelly. Now I'd like to again welcome back Edie, our first speaker, and we will take questions from both Edie and Kelly. As a reminder, questions and comments can be typed into the Q&A box seen in your control panel. We already have a lot of great questions that have come through, so I will start from the beginning here. So Christian asks, does a diagnosis of dementia automatically mean the elderly person is mentally incompetent? And I think you answered this a little bit, but if you want to go into it again or answer.
Absolutely not. A person who has a diagnosis of dementia, dementia, just like autism and just like the California law about capacity, is on a spectrum. And so I may have some cognitive decline and maybe some very early or even mild dementia and still be able to do things that don't necessarily require complicated executive functions. And so, no, it does not automatically determine that a person is incapacitated. Do you want to add to that, Edie?
No, I mean, you answered it clearly. It doesn't mean that. You need to go deeper.
Right, thank you. And then I have a question from an anonymous attendee. Who pays for the court costs and attorney fees if the conservatorship process is challenged by another family member or person? I think that's maybe a question more for Edie, but Kelly, if you want to jump in.
I'm happy to answer that.
Yeah.
So typically what happens is if the proposed conservatee has a large amount of assets, they will be charged for the attorney that's appointed to them. So if there's a proposed conservatee and a conservatorship action comes on board, the proposed conservatee is going to be assigned a court-appointed counsel. So they will be assigned a court-appointed counsel. Court-appointed counsel will be paid for by the county or state unless there are assets that are available. So it can get costly, but the court will pay the fees. So a proposed conservatee is always entitled to counsel, and that counsel will be appointed by the court if the person doesn't seek out their own counsel.
And then I think to piggyback onto what Edie's saying, the people bringing the conservatorship, right, especially someone who's contesting it, they have to cover their own fees, correct?
Yes. And also they usually have to pay, I think it's $800 for the court investigator fee. So there's also that fee. And of course, there can be fee waivers that are sought for lower income, but typically there's going to be those costs associated with it. So beyond just the petition, that's $435 to file, plus whatever filing fees for electronic filing, you're also going to have the $800 or so for the investigator.
Okay, thank you. All right, another anonymous attendee asks, what do you tell people who are worried that their family member won't pull the plug or refuse to provide the expensive procedure because it will affect said person's inheritance? Maybe a select person that's not in their will.
I'm not sure I understand the question, but I'll answer to the best of my ability. That is the benefit of having a healthcare directive and sharing it with your doctors so that you know, this is my wish. I wish to be taken off of life support, or I wish to continue my medical treatment until I have been determined by a neurologist to be brain dead. And they must honor that. It doesn't matter what anybody else wants. If I have a healthcare directive in place, whatever I say, the instructions in that directive should be followed. If someone's not following that, oftentimes you'll see this on television, these big court cases where someone's been in a coma for 10 years and, you know, one family member wants to take the person off of life support and the other person doesn't. And there's no healthcare directive in place. And now the courts get to decide, well, even if I have a healthcare directive, if someone's not doing what I have said to do in the healthcare directive, then that can be taken to a court of law.
To piggyback on that, I just want to talk about a POLST, which is a physician's order for life-sustaining treatment.
Yes.
So if somebody has been diagnosed with a dire medical, they have cancer and they're in late stages, they can actually, a POLST is on bright pink paper. It goes with your medical file, and you can literally dictate each area. I don't want life-sustaining treatments. I want to be brought back to life if this happens. A lot of elderly people, if they crash and then they go to revive them, it can crush their ribs and be awful. Now, these type of things, when it comes to a conservatorship, and there's a conservatorship of the person appointed by the court, that person can bring they can bring these POLST type questions before the court and get orders for the court. That's under a conservatorship. Now, your advanced healthcare directive can cover a lot of those questions if you choose to fill it out properly and you do it to the best of your knowledge instead of just leaving the person you nominate in charge of making those decisions. That's, I think, the question is how do you make sure that person does what you say? You make sure by putting it in writing. The pulse is something you do with your doctor and your treatment plan. That's a good way to go. Also, I tell everybody who does have an advanced healthcare directive, make sure that whatever hospital's near you, you can put it there on file. You can put it in your patient file. They'll have it. I know from personal experience, my dad had a fall. We were wheeling him into the hospital. And of course, one of the questions, do you have an advanced healthcare directive? Yes, he did. It was already on file. He doesn't have to think about it. Doesn't have to talk about it. It's done. So that's the benefit of that.
Right, and I'll just add one more thing. You know, you could be on vacation and be injured, right? And those doctors are not going to have access to those documents. That's why it's important for your healthcare directive representative to have a copy of all those forms, so that if they contact family members, or they contact your doctor again, right, through your health insurer, they find out who your primary care doctor is. Make sure your primary care doctor has a copy of that so they can provide it to people out of state or people who are unfamiliar with your condition.
Thank you. And then we have a question from Christopher that asks, is there a difference between capacity and competency?
No, they're actually interchangeable words. The capacity kind of speaks to the spectrum that Kelly talked about, that there's a very low level of capacity necessary to marry. There's a low level of capacity to actually prepare and sign a will. A trust has a higher contractual capacity, so you have to have a higher functioning, and it can be challenged if your medical records say you don't have the ability to make medical and financial decisions, and yet you're, signing everything over to the dog walker to give your house and everything, that can be challenged. So capacity and competency, competency is more of, I think they're synonymous, but capacity is the legal term that they're going to look at.
Okay, thank you. And then a question from Eric reads, what are your thoughts on someone creating an irrevocable trust to help prevent abuse by bad actors? And maybe that's a question more for Edie.
So an irrevocable trust can have taxation implications. It can definitely, I would say you need to talk to a very seasoned trust and estate attorney to deal with an irrevocable trust preparation. I have seen trusts that are designed that are somewhat irrevocable or require court approval for certain changes. But those are all going to have to be worked out in a very technical legal forum.
Yeah, and I would say the more you lock yourself in legally, the word irrevocable says it all, right? That means you're not going to be able to make any changes. It is what it is. And you're locked in. And what if, for example, if you put your real estate in there, right? Now, when you sell the real estate, the money goes to the trust because now it's irrevocable and the trust owns the money. So you can't disperse that in any other way except what is indicated in the trust. It's very complicated.
It also, if I can also just add, an irrevocable trust as opposed to a revocable trust. When it's revocable, it's tied to your social security number or the person's social security number or their spouse's. Once you set up an irrevocable trust, you have to get a separate employer EIN number, federal ID number for that, and have a separate taxation so that you have a 1041. So there's a different tax form. So it adds a bunch of things. It also could change the ownership of anything that goes in there to trigger a property tax reassessment possibly. So it has huge implications. And although it sounds like a great idea, hey, I'm just going to make it so nobody can ever change this, it has huge implications in the tax world. And also, if you do want to make changes, you have to go to court generally to make a change to an irrevocable trust.
Thank you. And then we kind of have some similar questions from Francis and Margot, but I'll start with Francis here. What is the process to revoke a power of attorney?
I can take that one, Kelly, unless you want to take it. You have to do it in writing, and you prepare a revocation. You need to serve it on, I would serve it on anybody in every institution that you think is being used. So you want to make sure if a bank had previously had a power of attorney, you deliver the revocation to that bank, you deliver it to the financial advisor, you deliver it to the person, and you let them know you are not to act. And so that's the start of it.
And Margot, kind of piggyback off that, what is the best way to revoke a power of attorney after a person has been declared incompetent by 2 doctors?
So it depends who's doing the revocation, right? If it's a family member and they're trying to revoke it, you're going to have to go to court. And if there's already been a capacity finding, it's going to be challenged. So that's again where it comes in, where Kelly was discussing, until you've been found incompetent by a court of law, you still technically have capacity, but that's going to be challenged most likely. And then you're starting the ball off on some kind of trust and estate or fiduciary type action.
Yeah, so that's exactly one of the examples that we talked about. You are, even though a doctor or 2 doctors have said that you're no longer able to manage your affairs, that doesn't have legal bearing. You can still revoke a power of attorney. Chances are, as Edie said, the person who's acting as your power of attorney and is being taken out of that position is probably going to challenge it and use those medical opinions in court, but you still have the right to revoke that power of attorney and serve your bank and other institutions who have a copy of that, as well as the person who is being revoked from that position.
I want to give a caveat to that. There are times where I've seen the financial institutions, they get an inkling that there's something awry and they're trying to revoke the power of attorney, and it's the elder doing it, but there was previously a power of attorney appointed, and then they get all freaked out, and so they shut it down. And all of a sudden, now your bank account's blocked. The elder doesn't have any access to their funds. The power of attorney doesn't have access to the funds. And then you have to do a lot of procedures to get it unhooked. So you have to be very careful that if you're going into that disputed realm, that you do it consciously and you figure it out, because there's nothing worse than, grandma can't pay her rent because her account got blocked by Bank of America because somebody thinks there's financial abuse at hand.
And then I have a question from Eunice. Asks, what point can a person who has signs of dementia cannot complete the advanced healthcare directive form?
Again, that's going to be a question for the attorney that's preparing it. Usually I would go with a POLST if somebody is really ill and there's questions of capacity. If they've already flipped over the line, nobody's going to do those documents for them. Typically, an advanced healthcare directive is something everybody wants to have in place. The medical professionals want to know who is the point person. They don't want somebody in the hospital that doesn't have an advocate or somebody calling the shots when the person can't call the shots. So I think what it really comes down to is the medical providers that are dealing with the patient. They're going to be able to say, yeah, you can't do an advanced healthcare directive if you're in a coma. Let's just say that.
Yeah, I would say that, you don't necessarily need an attorney to do an advanced healthcare directive. And on that capacity spectrum, choosing someone to manage your medical care, you don't have to have a lot of capacity. So unless you're severely incapacitated, it's probably going to be accepted unless there are obvious signs to the person you're trying to get to take the advanced healthcare directive, or the court if it's contested,
And
you have severe dementia. But you don't, just like, drafting a will, completing a will, advanced healthcare directive falls under that same very low threshold for capacity.
However, whoever you nominate on your advanced healthcare directive, they're going to have broad powers and will most likely be looked at as the person that's going to take the conservatorship if a conservatorship becomes necessary. So when you get into that window, that gray window, that's when it's really important to make sure that there's not a bad actor in the mix, because I have seen that, you know, a strange child swoops in and all of a sudden gets the paperwork signed and takes an upper hand. And those are the fights you don't want to have. That's why you want to try and do this before incapacity or competency is an issue.
Thank you. And just looking at our time, we have a lot of great questions coming in and only a few more minutes, but I'll ask a few more. So we have another one. Would it be appropriate for a power of attorney to be paid a fee? And would it be, would you put that within the power of attorney paperwork? This person shares that it seems like a very time-consuming task to be named as a power of attorney.
Well, typically when professional fiduciaries are put in charge and they retain the power of attorney, they have a standard fee agreement that they work out with the person that they're assuming the duties for. It is a very heavy lift, but you know, having been the power of attorney for both of my parents, you do what you do because you do it, right? So you have to have the wherewithal, and sometimes you do what you do just because it's the right thing to do, and there's no fee associated.
Yeah, and also it's not unethical if you're a family member who's become the primary caregiver and is doing all of these things for your parents and your other siblings are not participating and you're burdened with all this. It is not unreasonable to pay yourself a reasonable fee for your time. But again, you need to be very clear and keep documents, be transparent and share those documents with your other siblings if they should question you, because you want to avoid an allegation of financial abuse if you do decide to pay yourself. And that's particularly important if you've had to reduce your work hours to part-time because now you're busy managing the care of someone else full-time.
Thank you. And I just looking at our time, we probably have one more question here. One of the slides, Susie mentions that a trust requires an attorney. Can a trust that is drawn up through an online source or can I should say, a trust be drawn up through an online source or another way? And will it still be legally binding? And approximately too, from Celine, how much would a trust be to be drawn up?
So again, there's a huge the price varies depending on the complexity of the assets, the size of the estate. Can a trust be drawn up? Of course. I've seen a number of trusts. Now, my firm, we do trust preparation, but not as actively as we do trust litigation. So what I'm very familiar with are, you know, not to mention any providers, but people that kind of just think they're doing the right thing, putting things in a trust and draft it themselves, and then the terms just are not appropriate or everything goes awry and it ends up at court and ends up costing so much more than it would cost to do it right the first time. So there are plenty of trust and estate planners. You want to interview them. The online filling it in yourself, when you're doing too much filling in yourself, you might just click off something and then you have an irrevocable trust and you didn't know you were going to get one. And then you have all the problems we talked about in the earlier question. So I think that there are very reasonable trust drafters out there. There's also a lot of stuff coming online. So you just have to be careful because you want to make sure the terms are appropriate. When there's too many legalese and you're just lost in it all and you're not an attorney, the person that you're appointing to be the successor trustee is probably going to have a real difficult time figuring out what the powers are and what's going on in the trust. So, you know, I've seen a lot of them. So it's a spectrum, there's good, bad, and it's not necessarily you get what you pay for, but I highly encourage getting professional consultation when you're trying to put together something, especially if you have a complex amount of assets.
Yeah, and I would just add that I think that when you do it online, you have to pay for an attorney to review your trust. So I think there is a process like with LegalZoom. I haven't been on there in a long time, but the last time I checked into that, there's an attorney review after you put together all the information in the trust.
And just one last thing, when you do a trust, that's just a document. If you don't title assets into the name of the trust doesn't hold anything. So the trust is basically attached to your social security number, right? As long as it's revocable, but it gets a new EIN when you die. But whatever you put into the trust, so you're putting your house in there. So you have to do deeds to transfer your house from your name into the trust name. You have to go to the bank and say, hey, I just started a revocable trust. You have to tell your insurance company, I need to make sure my trust is one of the insureds on my house because I put my house in the property. So there's all those kind of things that you need to make sure you do. So sometimes when you're doing self-help, you don't really know that you have to do this other stuff. And you're like, well, I have a trust. And then it still requires a procedure on the other end called a Hegstead petition to get things into the trust.
Thank you both for answering those questions and also for today's presentation. I do have to apologize. I have to put a pause on today's questions. We do have a lot of other really great questions, and I again apologize we weren't able to get to them, but any questions that are not answered will be sent to our presenters, and hopefully based off of their availability, we will see if we can get them answered and out to our attendees in the next few weeks here. But again, thank you both so much. Lots of great comments in the chat and the Q&A, and I will hand things back over to Libby now.
Thank you, Tracy. And we'd really like to thank our presenters today for their time and the invaluable information they've provided. And I'd also like to thank Radiant Futures for sponsoring our opportunity drawing. And I want to thank the committee as well for all of their hard work to make this event possible. And most importantly, we thank all of you for being here today. So I'd now like to introduce Carrie DeLaurie from Providence St. Jude to provide important information about our post-event survey and CEUs.
Thanks, Libby. Attendees who complete the evaluation at the end of today's event will receive certification for continued education credits and would be entered into an opportunity drawing to receive one of 10 e-gift cards, each valued at $100. Again, you must provide your age range to qualify for the opportunity drawing. In addition, you'll receive a follow-up email with a link to view a recording of today's webinar. Be sure to share that link. On behalf of our committee and our presenters, thank you again for joining us and have a great rest of your day. We hope to see you again next year. Thank you.